But I'm challenging the order, my lord, contained at P11, my lord, P1, my lord, that is dated 12/10/2023, my lord. I filed an application under Section 9, my lord. I'm the husband, my lord. I filed an application under Section 9 before the family court, my lord, seeking restitution of conjugal rights, my lord. Now, my lord, a reply was filed, my lord, by my wife, my lord, and subsequently, my lord, an application under Section 24 was filed, my lord. My lord, I filed my reply, my lord. The court, my lord, has passed an order, my lord, deciding the application, my lord, granting 20,000, my lord, as maintenance to the wife, my lord, along with 3,000, which is the litigation expense, my lord. My lord, I am challenging, my lord, the quantum, my lord, and the fact that she was working prior to marriage, my lord. She cannot be, my lord, given that amount. That's my submission, my lord. My lord,
What is her present status? Whether she is still working?
She's not working now.
So your admittedly your last paid round is 60,000 odd amount.
Yes, my lord.
1/3 has been awarded to your wife.
20,000.
1/3.
1/3, yes.
Yeah, right. She is entitled for that.
But there are judgments of the Supreme Court.
She has a right
that 25%, my lord, is the.
She has a right to live as per your status.
That's right. But I have two full submissions, my lord.
1/3 instead of half, at least part.
The fact remains, my lord, that she does not want to live with me, my lord.
That is on merits. That is on merits. So Section 9 petition will be decreed at the most, and that will serve as a ground to seek divorce later on after 1 year.
There are two reasons, my lord. Two submissions, my lord. My lord. One is, my lord, that if she herself does not want to live with me, my lord, then she cannot be granted the, my lord,
for that finding has to be recorded that she has deserted you with some animus not to return back.
Lord,
it requires some evidence to be laid.
Lord, may kindly see, my lord, the order
of the basis of pleadings.
Yes,
quite premature to.
My lord, may kindly see, my lord, for a moment, may kindly see the impugned order, my lord. But there is absolutely no reason assigned, my lord. But that
case is at the.
That's right, my lord. Lord, my submission
evidence is still to come.
My lord, my submission is, my lord, if she has deserted, my lord, to the extent that she does not want to live with me, my lord. My lord,
that is yet to be ascertained by the court.
But she has simply in a reply stated that I am someone who demanded dowry, my lord. Look, that's her only stand, my lord, and absolutely no allegation against me prior to the filing of the
lead evidence before the matrimonial court and have a decree under Section 9.
Let me kindly for a moment see the order, my lord. My submission would be, my lord.
In any case, these.
Look, that is on the higher side, my lord. My lord.
How higher? Admittedly, you are earning
60,000, my lord.
60,410. Admitted amount. Yes,
that's an
out of 60,000, she has a right to live as per your status.
I have also pleaded before the court, my lord, that I have an EMI, my lord, which is a house loan for 40,000.
Beneficial deductions for you only. That's she has nothing to do. House has been constructed by you. You are paying some towards some monthly installments.
That's right.
House is you have invested.
But I will be left with nothing, my lord, for my maintenance, my lord. That's
my stand, my lord. Where she would go?
I am not, my lord. I am simply saying, my lord, that if somebody, my lord, has deserted, my lord, and is not willing to live with me,
that fact has yet to be ascertained. Who has deserted?
Lord, what has happened is
case is at initial stage.
That's right, my lord. But my lord, the fact that I am moving a Section 9 application, my lord, in itself means, my lord, that she does not want. She's contesting it, my lord. She's contesting.
Are you ready to deposit an amount towards litigation expenses for amicable?
Lord, what has happened is, my lord,
resolution dispute before mediation and conciliation center.
What has happened is, my lord, she has also moved an application under 125 at Shahidol, my lord. Over there, my lord, mediation is
subject to deductions. No, at this point only.
Yes.
Even if maintenance is awarded.
Yes, my lord. Rajneesh,
maintenance will be maintained.
Lord, my submission is, my lord, with regard to amicable settlement, my lord, that is already going on at Shahidol, my lord, in the proceedings under Section 125. Lord, I am willing to, my lord, go before for mediation, my lord. I have been going there also, my lord. She is one, my lord, who is not cooperating with the mediation process.
Then it would be futile for this court to try for such mediation also.
My lord, that is precisely the reason why, my lord, she does not want to live with me, my lord. She is well educated enough to have her own livelihood, my lord, and still, my lord, she is claiming maintenance, which is 1/3, my lord. I will be left with nothing at all. There are judgments of the Supreme Court which says at max she can be given 25%, my lord.
Other judgments are otherwise also.
It's either way, my lord. That's right.
Even army authority used to pay 33%. You are saying 25%.
It's either way.
And this is the army order that don't file any petition. Army authority used to deduct 33% from the salary itself and used to send to the wife straight in her account.
That's right.
Without there being any adjudication. This army order.
Lord,
You are saying 25%.
my submission, my lord, will be, my lord, at least, my lord, notices be issued to her. My lord.
Subject to deposit of how much? This is my
Lord, subject to the fact, my lord, that I
litigation expenses you will have to bear. Moment notice is issued, she will come to the court.
Lord, I've
She will
already,
engage an advocate like you who will charge lakhs of rupees.
Lord, my submission is, my lord, kindly see the impugn order for a moment. my lord.
Sir, I am ready to issue notice.
Yes.
Who will bear the litigation expenses?
Lord, if she is not willing to cooperate for the mediation, my lord, then, my lord, in that case,
In this
there will
case,
be no applicable settlement
mediation
at all.
has not been tried so far.
But she has been appearing in mediation.
There may be difference of mediator may yield to something also.
That's
The
it.
125 mediator may not be in a position
That's
to
right.
strike an amicable resolution. Here, mediator can or she may be persuaded to that extent. In your presence also.
If I may submit, my lord, I'm
25,000 deposit in the
How
court.
much, my lord?
25,000
That
litigation
is the higher
expense.
side, my lord. I will have
You
to
have
seek
charged.
instructions.
You have charged more than 25 for your
Lord, I will have
from
to
your
seek
client.
instructions with regard to that, my lord. I have to seek instructions with regard to that.
All right. And counsel for the petitioner seeks time to have instructions whether the issue can be tried before mediation and conciliation center of this court, subject to deposit of an appropriate amount with the registry of this court payable to the respondent as litigation expenses on her appearance. Deposit how much you will. Orally, I am quoting 25,000. If your
I'll
client
seek
is ready,
instructions, my lord. If that client is ready, my lord, then
then I will record it. This is my standard order.
Lord, if it can be taken on the 4th, my lord.